Hello everybody, I'm estate planning attorney Michael Redden, and I get asked a lot of questions about, can I just handwrite my will? Why does it have to be typed up and formal? And today we're going to talk about that topic. Before we get into the content, if you have any questions about this or any other kind of estate issues, or if you want to plan with me, go to setestatemeeting.com. That's setestatemeeting.com. And you can set up a meeting either over the phone or in person to talk about your estate planning needs. So traditionally, of course, you go to the lawyer or you have someone type up or really make a formal document for a will. In some states, you don't have to do this. In some states, you can handwrite out a will, and as long as it really keeps up with those formalities, some of them still even have to be witnessed and other things, but that handwritten will in some states is going to be recognized. In Minnesota, it's not. And if you are really interested about this topic, the legal term is called a holographic will. It means a will that's written out. And pretty much with the courts in Minnesota, anytime someone brings forward a handwritten will or something like that, it's pretty much a sure thing that in a will contest, that will is going to be stricken down and moved off. Most of the courts won't even consider bringing it forth to probate. People have tried to do those kinds of things. And if you want to have your will be effective and recognized for the court, then it needs to not be handwritten. It needs to follow all the formalities, have it typed out, it needs to be clear, it needs to be witnessed by at least two folks and signed and all that good kind of stuff. So while some states will allow for that, and there's still some people who try to get away with that little piece, you really need to be more formal about it. So if you're wanting to get your will set up, remember that the handwritten will not work. Handwritten codicil, where you're going to try and get change to your will with your handwriting, won't work. I'll probably have a video on that as well in the future. But the holographic will, the handwritten will, doesn't work. You're going to have to go through the formalities, have to have the two witnesses, and those witnesses have to be 18 years of age or older. It's going to have to be printed out and signed, and most of the time you probably should also have it notarized as well for the witnesses and everyone else. That extra piece where they're swearing under oath and having it notarized and saying, hey, I did this, I'm over 18, I'm of sound mind and body, and the person signing this will is of sound mind and body and over 18 and things like that. No one's putting them under pressure. Those are so important, and they're just not found in that handwritten will, and you really need them. That extra part where you're saying that you're over 18 and no one's pressuring, that's called a self-proving affidavit, and you never really have those things in a holographic will. And since no one's swearing under oath at the time that all these things were met because you just hand wrote it, we're really uncomfortable in this state saying that that will was not coerced. That will is really what you meant, and that you weren't under duress, and that you were sound mind and body. We just couldn't know those things, right? And when you really think about it, most of the time those handwritten wills, no one even witnessed it. Even if you told everybody what you're going to do and then you wrote it down, no one witnessed it. The court doesn't know if you changed your mind at the end point there, or how old it is, or really when it was dated, if anyone witnessed it, if the date's correct. The court doesn't know. So the court will not admit it to probate. So you got to have that formal will. And again, if you have any other questions or you'd like to plan with me, go to setestatemeeting.com. That's setestatemeeting.com, and you can set up a free meeting with me either in person or over the phone.